Let's talk now about some of the new regulations that are going to be affecting our industry, things that have been passed in the state legislature over the past year, and things that will be affecting us as we go into 2017 and throughout the year. First off, let's look at some of the changes to mortgage loan originators. There were two bills that were passed by the 2016 legislative session. The first one was Senate Bill 16014, and that one essentially is an alignment of state and federal mortgage originator disclosure requirements. Ultimately, Colorado's mortgage disclosure statutes were in conflict with many of the new federally mandated disclosure requirements. That would be the new loan estimate form and the loan disclosure form that we had with TRID. And this bill incorporates, sort of by reference, the federal protocol of mortgage disclosures and removes some of the duplication, the unnecessary, and quite frankly, sometimes really confusing forms and disclosure requirements. It also sort of aligns state mortgage fees and cost disclosures, and those now mirror the federal disclosures, and they include the appropriate forms. In the House, House Bill 161306 passed, and that's the alignment of state statutes governing mortgage loan originators with the SAFE Act. And this bill helps the Division of Real Estate with the enforcement of professional standards, as the prohibited conduct sections have been consolidated in this bill into one statutory provision. Just makes it a little bit more simple. And the bill also gives additional clarity and authority to the Board of Mortgage Loan Originators with regard to the uniform state test for MLOs and also the surety bond requirements for mortgage loan originators. Now, pertaining to homeowners associations, again, two bills passed in 2016 regarding that. First one is House Bill 161149, and that requires the common interest communities created prior to January 1st of 1992 to comply with the budget reporting provisions of the CCIOA, the Colorado Common Interest Ownership Act. A lot of issues there as far as reporting of issues, making sure people receive timely notice of it, and know when certain meetings are going to be. Another bill that passed there was House Bill 161005, and this is the interesting one because this one dealt with the use of rain barrels to collect precipitation from residential rooftops. And in the bill, a rain barrel is defined as a storage container with a sealable lid that's located above ground outside of a residential home, and that's used for the collection of precipitation from a downspout or a rooftop. In the bill, a single-family residence is defined as a private residence that's a separate building, or an individual residence that's part of a row of residences that are joined together by common sidewalls. It could be townhomes, apartments, something of that nature. Now, precipitation from a rooftop under this bill can be collected if no more than 2 rain barrels with a combined storage capacity of 110 gallons are utilized, that the precipitation is collected from the building that's primarily a single-family residence or utilized for that the precipitation is only utilized for irrigation of lawns and gardens, and that precipitation is used specifically on that property. It can't be used for drinking water, it can't be used for household purposes, and the use of the rain barrel does not constitute a water right. And of course, the state engineer's office is going to monitor this and make sure that there's no abuse to this. Also, the bill gives a common interest community the reasonable ability to govern the aesthetic qualities of the rain barrels, and they can govern the appearance of it and the placement of where those rain barrels are. With regard to title, Division of Insurance has revised, again, in this case, their Regulation 3-5-1. And there's a few different areas in 3-5-1 that have been revised: rates and fees, consumer protection, standards of conduct, and fiduciary duties. And we're going to look primarily at the standards of conduct in section 8-1-3. And in this section, it prohibits the title industry from entering into marketing service agreements. So you say, what's a marketing service agreement? Well, they essentially are framed as payments. They're known as MSAs, and they're framed as payments for advertising or promotional services. But here's the problem. Some title companies have been utilizing these payments, and they've been utilizing them as cover. They're disguised really for compensation for referrals, which, as you and I both know, would be a violation of RESPA. And likewise, too, this bill also talks about that if a title company is providing a class, they have to let everybody know that it's the title company providing the class. Now finally, dealing with new regulations, we're going to be looking at the sunset review and recommendations. So first off, what is a sunset review? Ultimately, the sunsetting process allows the General Assembly in Colorado to review regulatory functions. A sunset law is a law that automatically terminates a state regulatory agency, a board, or a function of government on a particular certain date. These reviews, these sunset reviews, seek to balance the need for regulation to protect the public interest with the need to ensure that industry and professions are not over-regulated. So in the sunset review process, an executive branch conducts an initial review of entities and functions, and the executive branch in this case is the Department of Regulatory Agencies. They serve as the executive branch department responsible for conducting a study of the entity or the government that's under question here prior to the legislative sunset hearings. They produce a sunset report on or before October the 15th for each entity that they're looking at, and they present that. Now, if a entity is looking at potentially sunsetting, it would sunset July 1st of the following year. This sunset report describes the history of the entity, examines the laws that created the entity, and makes recommendations regarding changes to the laws and maybe the continuation or the discontinuance of the entity. Now, the General Assembly then conducts public reviews of all the regulatory functions. The General Assembly is sort of the legislative body, the legislative committee of it, reviews those recommendations from the Department of Regulatory Agencies, and then they hold public hearings that look at the report that was published and some of the recommendations of that report. So they review the entity, they review the functions based on that report, they look at the several options for recommendations, and they follow essentially the same procedures as other bills during the legislative session. So let's look at some of the recommendations that were made for the Division of Real Estate. It doesn't mean that these have been implemented yet. They're simply making these recommendations for implementation. First off, number one recommendation is that real estate brokers and subdivision developers should continue to be regulated. So that means the Division of Real Estate is not going anywhere. It is staying put. It's not being shut down. It's still very viable. It's going to continue. Second recommendation was more semantics than anything. They encouraged the deletion of the word standard and including those from section 1261.803.4 of the Colorado Revised Statutes. And this section deals with the ability for a licensee to prepare and use pre-approved forms from the Division of Real Estate. Once again, mostly semantics, does not change our authorization to work with pre-approved forms from the division. Another recommendation was that there needed to be a license endorsement created for property managers that requires prescribed education and financial surety as conditions for the endorsement. Essentially, the idea is that property managers deal with different issues than your typical real estate broker doing real estate sales, and that their education should be in harmony with that. Likewise, they're recommending a minimum amount of $100,000 surety bond to protect the money of others that's in trust with property managers. Another recommendation was to strengthen the requirements on becoming an employing broker by essentially requiring the commission to establish the number of transactions that somebody would have to have completed in order to become an employing broker. Right now, to be an employing broker, you only have to be active in the business for 2 years and take a class called brokerage administration, and then you can apply to be an employing broker. So you could have done nothing for 2 years, take a class, and then be an employing broker and have all the supervisory responsibilities we talked about in this class. That doesn't make a lot of sense. This is a smart idea that there need to be a number of transactions behind the ability to oversee the actions of other licensees. Another recommendation was to amend the statutes to conform to the Real Estate Settlement Procedures Act of 1974 concerning referral fees. Now, these are referral fees that are between settlement service providers, lenders, attorneys, mortgage brokers, things of that nature. And with very limited exceptions, RESPA does not allow referral fees. But here's the problem. Colorado law appears to contradict itself in allowing referral fees in one statute but stating that the laws have to conform to RESPA in another statute. Obviously, that's very confusing, and we need to make sure that we're in conformance with the Real Estate Settlement Procedures Act with Colorado law. Another recommendation was to create one cash fund for all division programs to simplify things. Another was to revise the license renewal laws so that all licenses expire on December 31st. Right now, essentially, they're expiring on the anniversary date when a license is issued. This is taking it back to the way it used to be, where all licenses will expire on December 31st. It's still probably for a 3-year term, but everybody's going to expire pretty much at the same time. Again, it hasn't gone into effect yet, but that's the recommendation. Another recommendation was to authorize the Commission to consider deferred judgments as a condition for licensure. And a deferred judgment is where somebody goes in front of the court and they're found potentially guilty of something. A judgment is there, but it's deferred based on the actions or inactions of a party. But the Division of Real Estate is saying maybe we should take those into consideration, even though they haven't necessarily been found guilty or haven't been convicted of a crime per se. Maybe we should take those in consideration on the issuance of a license. Another recommendation was requiring the Commission to develop guidelines for the annual Commission update course, which you're taking right now, and developing guidelines for it rather than developing the course themselves. So what they would do in this case is they would send out the outline of what needed to be covered, and then they would have oversight on course providers as they developed the annual Commission update course. We'll see if that comes about. And finally, the last recommendation was to modify the Commission's composition to include a licensee on the Real Estate Commission that mainly works as a property manager. Right now, all you have is real estate brokers, members of the public. But they're saying it might make sense now to make sure that somebody who sits on there represents and is primarily a property manager, especially since we deal with so many potential property management related issues. And those are the recommendations that came out of the Sunset Review.